as circulated in my name. In a recent survey of constituents of Wentworth, repairing our broken environmental laws was top of their environmental priority list for 2024. They wanted to see a parliament finally act Graham Samuel's review of the EPBC Act, which is now getting on for 4 years old. And they wanted to see a comprehensive response to the devastating State of the Environment report, which made the clear extinction crisis facing our country. And when I held a forum in Bondi last Sunday with youth advocates Anjali Sharma and Lottie Dalziel, the message was equally clear. Parliamentarians have a duty of care to younger generations, a duty to strengthen our environmental laws and to do everything we can to prevent the accelerating and devastating climate crisis. And this is why I'm speaking on this bill. Section 790E of the bill, introduced to this House, provides a Resources Minister with an extremely broad power to change the rules governing environmental approvals for offshore oil and gas projects. Under the bill introduced to the House, changes to rules around environmental approvals would have been made without the oversight of, or even the involvement of, the Environmental Minister, and they would not have to be inconsistent with the provisions that currently exist under the EPBC Act. As the Biodiversity Council, an independent expert group founded by 11 Australian universities, set out in their submission to the Senate inquiry, this bill is wrong in principle because it will indefinitely override an important environmental protection under the EPBC Act. It is inconsistent with the government's Nature Positive Plan, and it takes an objectionable approach to legislation because it buries these changes in a bill that is supposed to be about worker safety. It is a bill opposed by many First Nations leaders who have come to Parliament today to ask the government not to pass it. And I believe the government should listen to these First Nations leaders and should remove the Section 790E of the bill altogether. But if it cannot remove it in its entirety, there must be safeguards put around it. Along with other members of the crossbench, this is what I've been pushing the government to do. At a minimum, we need to see the Environmental Minister consulted before regulations are made, and we need to see this consultation consider whether regulations made by the Resources Minister under the extraordinary powers conferred by the legislation are consistent with the principles that underpin the EPBC Act. And that is why I supported the government's bill and the government's amendments, and welcomed those pieces that did that. However, the government amendments still leave a lot to be desired. There are gaping holes in this legislation. Merely requiring the minister to be satisfied that regulations are not inconsistent with the high-level principles of ecologically sustainable development is a very weak test, and it is much weaker than the law currently provides. Under the current EPBC endorsed program, there are detailed requirements around how matters of environmental national significance should be protected, and regulations are then made to operationalise these. Compared to this concrete detail, a subjective test against a few high-level principles offers only minimal protection. At the very least, we need the Resources Minister and the Environment Minister explain why they are satisfied that regulations are, or are not, consistent with the principles of ecologically sustainable development. We need their reasons, their explanation, their justification for any new regulations made as a result of this law. And that is what my amendment will do, and that is why I have moved this amendment. It would compel the Resources Minister and the Environment Minister to table their opinion on whether regulations made under this bill are consistent with the principles that underpin the EPBC, and explain the reasons why. It is an important transparency measure. It would improve the integrity of the amendments already passed today and would make a bad bill a little bit better. I note I have tried to engage the Environment Minister's Office and the Resources Minister's Office regarding this, and I note that the feedback I have had from the Resources Minister's Office is that they don't have enough time to consider these. These are amendments based on the government amendments which I got on Sunday, that we then did the work on yesterday to try and provide a useful amendment to the government's own amendments. And then I was told by the Resources Minister's Office that it looks like they didn't have enough time to consider these amendments. This is why this bill shouldn't be rushed through like this. This is why the debate should not be gagged like this, as it has been throughout this bill. And this is why this piece is so important. Finally, I'm also deeply concerned about the implication of Clause 2(1)(d), which states that even a failure to comply with the new provisions does not invalidate any regulations made under this Act. That is, even if you don't want these amendments, if you don't do what the government's amendments have provided for, doesn't matter. And if this is the case, it's a shocking loophole. Some people are calling this provision a get-out-of-free-jail card. And so I welcome the minister's clarification onto the point on the government's own amendments, which I wasn't allowed to speak to because the government was gagged my debate and stopped me speak earlier on this bill.